bringing in Keith now, and I'm going to clip this portion of the interview and post it to Viva Clips tomorrow, so that we can have everybody see it, because Keith doesn't have some explaining to do. The government has some explaining to do, and we're going to need Keith to do it for us. Keith, get ready. You're on.
Hello, can you hear me?
I can hear you, and now the inquiry, I think, is on break. Yes. So I'm not going to be hearing the inquiry and you at the same time. Let me bring you in a little closer here. There we go. Keith, let me ask the question that I think everybody's asking. What does it feel like to have your heart ripped out of your chest and then have a judge stomp it on the ground?
Well, disappointing, very disappointing. And the reason I find it so disappointing is Viva, I think you know that I have been criticized by others in our profession, other lawyers, and they're in a pessimist class. They've criticized me for, like, why are you doing this? You know, why are you trying to uphold charter rights in Canada right now? And the reason is that, first of all, I think our charter rights are fundamentally important. Basic human rights and freedoms are critically important to live a successful and a good life. So it's critically important. But the way I look at it is this: either the institution is real or it's corrupt. And in my view, the best way to reach the proper conclusion about that is to bring carefully crafted, properly founded, procedurally accurate charter challenges before the court. So that's what we did. Premier Peckford, the last living signatory to our Constitution and our charter, remarkable, is my client, along with a number of other applicants. And he fundamentally believed that his right to mobility was obviously violated by the federal government's travel mandates. So what I believe is that we need to give the court a chance to prove itself as a worthy institution, or we need to allow the court to expose itself as a corrupt institution, because it's only through that exposure that reform can occur. So, you know, that's why this case is so important. It's just one of the reasons it's so important. There are many. So when the court, at a point in the process where, as you know, and your viewers will know, the government put forward 16 witnesses, 5 external experts, 11 internal of the highest officials that the Prime Minister and the ministers kept claiming they were relying on for the advice of experts to justify restricting millions and millions of Canadians' rights. You know, that was an exhaustive process, as you and I have talked about, and it's amazing. I mean, the motion record, the compendium of evidence, is approximately, just under 15,000 pages. And so here we have this full case ready to go. We had our factums completed. We had the only thing that needed to occur that hadn't occurred is next Monday, the 31st of October, we were supposed to appear before the court for oral argument. All the evidence was filed. All the factums are done. So instead, the federal government, their lawyers, brought an application seeking to strike out our claim and prevent the court from hearing and finishing it on the grounds that it was moot. We had an oral hearing before the court here in Ottawa, where I am now, but for the inquiry, on the 21st of September, and we made the case as to why this case wasn't moot. And as you know, the court issued a quick ruling last week, in the sense, or a brief ruling without reasons, late on a Thursday afternoon, advising us that the case was being thrown out and struck. And
let me stop you there for just one second, because it's the curse of knowledge. For anybody who doesn't really know the absolute 30,000-foot overview, Brian Peckford, Maxime Bernier, other petitioners challenged, asked for judicial review on the basis of charter violations for the Trudeau mandate that unvaccinated Canadians could not board planes and trains. Charter violation. It goes through the courts for about 9 months, 16 witnesses, the whole process, the whole shebang. In the interim, at some point when it becomes politically unpopular, Trudeau suspends the impugned order and then says, well, now that we've suspended it, Your case no longer has an object, no case in controversy. They made a motion to strike for mootness. That was argued, and it was granted. And that's where we are right now. And Keith, it was a very short, succinct judgment that came virtually a month after the hearing. No reasoning, because they'll say we'll do that in due course because of the urgency. How did it take a month for the judge to allow you guys to know not to prepare for the upcoming hearing, which started 10 days later?
Well, and we had already started preparing. I mean, as I was coordinating with the other lawyers, both my team and the teams of lawyers for the other applicants, because it's a consolidated application, so we all work together as required. I remember sending an email to the team, the broadest team of our lawyers, on the Monday that we did finally of that last week, saying, okay, now they're jerking us around. Like there's just no way that this should take this long. The court knows full well that we're locked into preparations. We're burning through our clients' legal money, and limited money it is. And so I'm just very disappointed. I think it was bad form on part of the court. If that was their decision, why did it take so long to make it, especially without reasons? I could possibly see a decision taking that long if there was a comprehensive set of reasons that went with it, but there wasn't. So I'm very disappointed in the court. And it's part of a trend. It's part of a trend that we've seen, although, as you know, as you and I both know, there was an aberration in the trend, fortunately, yesterday, or was it the day before, in Nova Scotia?
Yeah, we'll get there.
But where a court went, what I think, the right way. But the courts have just been so reluctant to touch anything related to COVID, to touch anything related to the charter and COVID, anything related to these outrageous government overreach actions, whether it's the Quebec government's bizarre curfews, to the forcing businesses to close, to shutting down playgrounds and swimming pools, to preventing us from gathering at Christmas and at funerals and at weddings. All of these things. The court has to deal with this stuff, and whether it's awkward and difficult is not an excuse. And it just really feels like the court's become politicized.
Keith, before we even get there, just so people appreciate this, because the hearing was on September 21st, and we did an interview on the 22nd. And yes. I agreed. I don't know who said it, but it was common sort of assessment. The longer the court took to issue a decision, the less likely it would be to dismiss it, because it was a 5-day hearing, oral arguments that you had scheduled. Was it 5 or 10 days? How many days?
5 days starting next Monday, October 31st.
So 5 days arguments. It's not, you don't prepare for that the day before, the week before. You have 15,000 pages of evidence. You prepare for that. You were probably preparing for that before the motion to strike on mootness. How the judge then waits nearly a month for an unmotivated decision, where the judge presumably knew that's exactly what it's a male judge, he was going to say. I don't know if it's a male
no, the judge, there was the deputy chief justice of the federal court that heard our case. So it was not a judge of insignificance.
No, so the judge hears it. The judge knows that he knows where he's going. It doesn't take a month to let you know, no trial, and you've been preparing for 3 weeks. I mean, I don't know if it's a question you can answer. To me, that feels deliberate. That feels like a needle above and beyond everything else to make you burn through your client's money. Peckford is burning through actual money. The government probably preparing as well, burning through our money. Is it deliberate? Is there any rational explanation for it?
Well, I mean, I can only speculate, but and base it on my experience. I've been a litigator for 28 years and done many cases and lots of judicial reviews against governments. And I just thought it was highly unusual to verging in on improper, that the court would wait that long, knowing full well the magnitude of evidence and complexity of evidence that we were working to distill for a cogent argument and in a coordinated manner between 4 different applicant groups. So I'm very disappointed in what the court has done.
Now, another thing I've heard, and I'm not sure what the applicable rule is, that you have 30 days to appeal, but is the 30 days from the unmotivated judgment, or is it 30 days from when you get the actual reasons so you know what you're appealing?
It's 30 days from the short decision that says your case is dismissed, reasons to follow. However, fortunately, unlike other forums and jurisdictions, the federal court does have a provision that allows for an extension. And even if they didn't, we would file an appeal on the 30th day. And one of the reasons for the appeal would be failure to provide reasons. So,
Okay, so some silver
we're
lining.
not, and just to be clear, because you know the answer, but for all of your viewers, we are appealing. I phoned Premier Peckford immediately upon receiving the decision. And I said, sir, my recommendation is that we appeal. And what is your instruction? He said, absolutely, you are appealing.
No expletive. I not that I think Peckford swears, but if there's a time to swear, that's the time a polite person would swear. If I may ask,
well, he gets this incredible resolve in his voice. It's just, he's such a leader. You know, we're so gifted as a country to have had him as a premier, and you look at his accomplishments, you know, have him as a founding father of our charter, and now have him having taken such a strong stance in support of Canadians' rights and critiquing government overreach has been, we're very fortunate.
Yeah, fortunate. And then, I mean, you compare a leader like Peckford to current administration, who I will not even call a leader for the sake of it, but I won't ask you. That's my opinion, Keith. You're not guilty by association. So, I mean, obviously going to appeal. Are you going to need or have issues raising funds? I mean, how is that going?
We need help. So first of all, you know, I've asked to keep our discussion focused on Peckford right now. You know that I've just come out of the hearing room on the public inquiry. So the Justice Center is supporting two legal teams here at the public inquiry, and also is funding the appeal for Peckford. And so our burn rate is very high. I have offered a further reduction in my hourly rate to help with the staying power. But yeah, if people want to help, they could go to the Justice Center for Constitutional Freedoms. The nice thing about donating through the Justice Center is it's safe. You won't get your bank account frozen.
not yet. Closed. Who knows?
Well, you know who's going to defend you. We're ready. And you get a charitable receipt because they're a full legal charity. So you can actually get it can be a wash for you. For what you donate, you actually get the same discount on your income taxes. So
I'm going to go back and that. I'm going to give more as of the time we end this, but I'm trying to find is there a specific link? I'm on the website now for
there'll be a drop down, and you can either pick it'll be the Travel Mandate Challenge or Peckford Travel Mandate Challenge, it'll say, and then there'll be another one that'll talk about Freedom Trucker ones for those who are interested in supporting what's going on at the public inquiry and all the criminal defense for Chris Barber and others. So yeah, that would be very, very much appreciated. I haven't been bringing that up much lately, but we could sure use some help.
I'll put the link there, and then I'll put the specific sublink afterwards when I can find it. So you're going to appeal. Now, I talked about it yesterday because I think it just came out yesterday. Nova Scotia Court of Appeal, Provincial Court of Appeal, not federal, overturned their prior injunction on outdoor protests because of security. Pretty scathing judicially court ruling. It said, obviously, ex parte hearing on an injunction, totally improper. Their expert witness probably should not have been recognized as such, and they way overstepped the bounds of science and law. And they said, we agreed to hear it despite the argument for mootness. Is that going to help you in any meaningful way? It's a provincial appellate court, but will that have any sway, any influence on a federal court of appeal?
I think so, for two reasons. One is legal. As you know, the principle stare decisis and other precedents influence, but there's a hierarchy. And so a provincial level court, even a superior court, is not binding against the federal court. However, I think it's helpful. It informs the court, and it's something that they should consider and they're required to consider. But it's also helpful at a more practical level, because it always takes that one person in the crowd to stand up when the others are sitting nervously and perhaps too afraid, or too complacent or just drank the Kool-Aid to say, no, this is wrong. And when one stands, another can stand, and more can rise. And so I hope that's what we see happening here. We've had our our Court of Appeal in Alberta issue a very strong ruling in the Pastor Pawlowski case with some very strong and proper judicial condemnation of the flakiness of the lower court decisions and their rush to be cheerleaders for government policy without critiquing it and making their decision based on the evidence. So I'm hoping this is part of a pattern. And it doesn't matter because I've been on your program a few times, and I think one of the things you've learned about me is I'm a little bit on the stubborn side. So we're going to keep going, man.
Well,
they think they're discouraging me. They're wrong.
Well, I mean, I guess that's a good segue into what's going on now at the with the Emergencies Act inquiry. That's all the news for Peckford. There's going to be.
Let me just do a map out for everyone, because Peckford was even needed help on, wanted certainty around what I'm about to say. So here's the road ahead. We filed the appeal against the mootness motion, or the mootness ruling, to strike our claim. So our claim struck. That gets heard by the Federal Court of Appeal, because we're currently in the federal court. So we go to the Federal Court of Appeal. If the Federal Court of Appeal agrees with the federal court and says, no, that was the right decision and your claim struck, we will then appeal that decision to the Supreme Court of Canada. Okay. And we may, and to go to the Supreme Court of Canada, you need leave. So you'll seek leave, and then you either they say, no, we're not hearing it, in which case you're done. Or they say, yeah, we'll hear it. If we go to the Federal Court when we get to the Federal Court of Appeal, and the Federal Court of Appeal says, you're right, Mr. Wilson and all the other lawyers, that the court got it wrong and should not have struck down your case and should have held that hearing, 5-day hearing, on the 31st of October, we then go back to the federal court to run that 5-day hearing. Of course, that'll be at some point in the future. And if after hearing the 5-day hearing in the federal court, they rule against us and say that it was demonstrably justified for the federal government to restrict 6 million Canadians' fundamental right to travel by train and plane, preventing millions of Canadians from being at the side of dying loved ones, attending funerals, going to weddings, the birth of first grandchildren, caring for loved ones, discharged from hospital, or being at important social events, whether it's 50th anniversaries or graduation ceremonies. If the court says, no, that was okay, then we'll appeal that as well. So we're just going to keep going, because as I've said before, I've said it many times, and you're going to keep hearing me say it, which is Canadians need to know, does the charter mean anything? Like, were we all duped? I think I joked on your program that I was going to sue Osgood Hall for my constitutional law class, because my professors told me that it actually was a real substantive document that conveyed real rights to Canadians and limited government overreach. So we need to know, and we're going to keep pursuing it. So that's the road ahead.
Well, if there's a university that at this point deserves to be sued, it might be Western, specifically for their booster mandate. I don't know if they took that back.
Ridiculous.
So just so everybody also appreciates, Americans, if you're watching, we've got state courts, we've got provincial courts and federal court system, much like states and the federal in the United States. If the mootness gets appealed, if it gets upheld on the mootness, goes to the Supreme Court. I guess the federal government could appeal the reinstatement of the lawsuit, but probably wouldn't. That would have minimal chances of being heard by the SCOTUS, Supreme Court of Canada, SCC. Yep. Then it goes back for the merits, and if you win on the merits, they probably take it to the Supreme Court. If you lose on the merits, you take it to the Supreme Court. One way or the other, in 2 to 3 years, we'll have a resolution. That might not make people very, very happy or very encouraged, but we'll see what happens to the world between now and then. The Emergencies Act inquiry. You're there now watching this, and you're attending with your team. all day long, every day, right?
Yeah, they're long days. As you can maybe hear in my voice, I'm recovering from a cold. I ran myself down too much and got knocked out of action for a few days just as the hearing inquiry was starting a week and a half ago or 2 weeks ago. But it's been fascinating. I represent, I represent Tamara Leach and Chris Barber and Danny Bulford and Tom Marazzo and many of the other original volunteers that came together to make this Freedom Convoy what it became. And as you know as well, myself and Eva Chipiuk arrived on the ground on February 2nd with the support of the Justice Center for Constitutional Freedoms funding us. And we provided on the ground legal help to the Freedom Convoy in Ottawa. We did the negotiations with the city manager and then later with the mayor and got that deal. So this is it's a little strange to be back in Ottawa for me, but this inquiry is a very serious process, and they're very long days. We're up to over 20,000 records, and a record can be as short as one page and up to many hundreds or thousands. So we're up to about 50,000 documents, and we get new documents every day. So, and we have to identify the witnesses that we intend to cross 3 days in advance. We have to disclose the documents that we're going to put to the police and the government witnesses 3 days in advance. And then we get to ask for how much time we want to cross-examine, whether it's interim police chief Bell, who unleashed the goons, or whether it's the commissioner of the OPP or whoever who's testifying right as we speak right now. And so let's say we want an hour and a half to cross-examine them, and then we get our allocations the next day, and it's like, you got 20 minutes. So a lot of people, we're getting a lot of emails from people. Why aren't you asking this? And why aren't you asking that? Well, actually, those questions were on our list when we were planning for an hour and a half. So then we have to triage.
And watching the judge is consistently reminding witnesses to go slow. So it's not like you could even have them talk at the speed which some people talk. They got to go slow. That's just limitations.
Well, one of the things you may not picked up on, but you might have, and if you reflect, it'll become clear, is in the early days, we were putting up lots of documents, but then we realized you'd say, okay, bring up OPP 5017362. And then you're waiting and you're waiting and you're waiting, and then finally the document comes up, and then they got it crooked, so then they got to rotate it, and then they got to scroll up and they got to scroll down, and some of the legal teams only get 5 minutes to cross, and then you just chew through 2.5 minutes. Yeah. You just chew through 2.5 minutes of your time trying to get a document up. So now you might have noticed that most of the lawyers, they put propositions to the witness. We shifted our posture very quickly once we saw this, and what you do is you say, there is this document, it exists, and it has these words on it. Then you put the question to the witness as opposed to waiting for it to come up as you normally would. So we've had to adopt. We've also held off showing videos. But yesterday we transitioned, and it was planned. And we showed a video of a Canadian being pulled in their snatch and grab technique. As you know, when the police line would come up and they would wait, and then they'd open the line and they pull the Canadian, and then the line would close. And then you can see him thrown to the ground as they're fighting with him. And then you can see a police officer with his anti-riot gun just smashing this thing, muzzle end first, not even butt end. Not that it would have felt better, that much better being the butt, or, so the stock end of the gun. And the room got very quiet when that video was played. And we're going to be trying to do a lot more of that in the coming days.
Well, forget, I'm no gun aficionado, but forget comfort. Muzzle end really increases the likelihood of a fatal mishap if someone pulls a trigger.
Absolutely.
What time of day was that at? I might just go back and snip and clip so that we can.
It got played twice in the hearing yesterday. So if you go back and just power through it, you'll see the video pop up. Actually got played 3 times because another one of the other legal teams brought it up in cross. We put it in our cross-examination of the police officials. But at a high level, Viva, I warned Chris and Tamara and Danny and Tom and others. I said, get ready, because this hearing is just about 2 months long. We're not even close to the halfway point. I've never had to be away from my family on a case for this long. I warned the whole team. I said, we're not going to Ottawa for a case. We're being deployed. Like, we've really had to adopt a military kind of mindset that we're on a deployment, because we just work day and night, 7 days a week. But anyway, I had to warn Tamara and others that, be ready for one of the most difficult experiences of your life, of witness after witness coming forward with complete fabrications, recharacterizing what happened in Ottawa in the most negative light imaginable. Well, I was wrong, thank goodness, because every day, it hasn't happened yet today, but it might still yet, we sit there and we go, why aren't we at home already? The evidence that has come out against the government has been absolutely spectacular. Like, even when they first brought up the Ottawa residents to complain, like, we found out, the horror of hot tubs, horrific. That was how the mayor described. And then the protesters had hot tubs, and it was horrific. You usually don't get the word hot tub and horrific in the same paragraph.
There's a video of a woman who allegedly had diarrhea in a hot tub. That's horrific. But
yes, that would be horrific. But there's been no evidence or nor allegation of that. Like, they could have thrown that in. But what we did find out is that some people felt that Uber Eats was not as available as it was prior to the protest.
Keith, I was watching it, and people are watching it saying, well, yeah, why isn't it over? The evidence is not just scant, but damning against the government.
Yes.
That's part and parcel of the reason of this commission, is get that evidence out there so that, in theory, there could be a harshly worded conclusion against Justin Trudeau that he had no basis to invoke it. It was pure abuse of power. But listening to the highlight for me thus far, above and beyond Zexy Lee talking about how some residents might have gotten their hands on some eggs and might have had their little reprisal. It's like, oh, so there actually was violence there, and it came at the hands of residents of that high rise. What's her name? Catherine McKenney and Mathieu Fleury. When they were testifying, first of all, when Mathieu Fleury was talking about the microaggressions, people getting stink eye for wearing a mask, A, it's a lie, but B, even if it's true, that's the best they got. But I mean, were people laughing? Were people saying, my goodness, Catherine McKinney is an absolute joke, when she whispered to him on a hot mic to answer in French to frustrate Brendan's ability to conduct his cross? Were people gasping at the bad faith gesture that was?
Well, the audience does react from time to time, and there's a number of supporters of the freedom rights movement that are in the gallery each day. And I have spoken to them at time to time, and I have explained to them that, given the nature of this proceeding, the best thing you can do to be helpful is be silent at all times. Because if they react in a way, it actually distracts the commissioner and his legal team, his helpers, from focusing on what just happened. So, as you know, it's just not helpful. This is not the place to do those sorts of things, and most of the audience has been very respectful. And the other thing too, that we're in a completely different world now, and systems and processes of institutions haven't adopted. What am I talking about? Well, the best example is the hot mic. And what do I mean by that? Well, it actually wasn't that obvious in the room because she whispered. But what do your viewers and others do when they watch that and they clip that and they go, wait a minute, did she just whisper to him? So they stop it and they play it back, and they know how to adjust the sound settings, and they crank up the audio, and they go, and you can hear it clear as day. And then when the guy goes to speak, they bring the audio right back down. Otherwise your ears are going to blow out. Right. So, and then they clip that, and then they put it up on social media, and all of a sudden everybody sees the hot mic moment. And so we're in a different time. We adopted a very deliberate communication strategy. That's partly why I'm not in the hearing room right now, because communicating with you is very important in getting accurate information out, and it's part of our communication strategy. We have no confidence. I've been scrummed a few times by Global and CTV and CBC, and I'm like, I can guarantee 100% this clip won't get on the news because I'll say something bad about the government. It's like they're not going to play it.
Keith, it's a joke, and I'm watching Rachel Gilmore from she's live tweeting from Global News, and they repeat like gospel. Jim Watson, was it Jim Watson who said somebody came down from New Brunswick with guns in his trunk threatening to kill him? Mm-hmm. Keith, I just asked the question, and maybe there's a police report that shows it. Was anybody arrested for issuing threats?
Oh no, you've noticed that I don't take the podium, right?
Yep.
And that was a very conscious decision I made to step back as lead counsel.
You are going to be. Are you going to be a witness at some point? I think I saw.
Yeah, that was just confirmed publicly this morning, and I'll be testifying next Wednesday.
Okay.
And that's why I've stepped back as barrister. So we brought in. I searched far and wide, and I was really happy to find Brendan Miller and Bathsheba, and very pleased that they were willing on short notice to, hey, can you get rid of all your existing cases and come to Ottawa for 2 months?
People who don't practice law might not truly appreciate, if you're not at a big firm where there are other lawyers to take your files, and even that takes a lot of work. People won't appreciate. It's like not like going on vacation. It's like
well, and not only that, be involved in one of the most controversial historic cases of our lifetimes. So, most lawyers, too many lawyers are afraid at the career risk of doing the type of work that I and my legal team do. Anyway, what's been remarkable is the damning evidence that's come out. Like the best they got is, and so we have a social media team, and as soon as they started talking about Uber Eats, we had everybody start posting all their Uber Eats receipts from the protest, right? And so everybody's like, well, I got Uber Eats every day. I don't know why you didn't get Uber Eats in downtown Ottawa. So we're trying to counter them in real time, counter their misinformation. And we're going to keep doing that. The other thing that was remarkable is the level of complementary nature of the evidence from so many police officials about the extent to which the protest organizers were always seeking to stop lone wolf crazy people from doing silly stuff, the extent to which they were always advocating that it be peaceful, the complete absence of serious criminality that they found, the absence of any evidence of terroristic activity, the absence of any evidence of all of any one of the criteria that are required to invoke the Emergencies Act. I mean, the most spectacular one, where we literally joked, where we were going to call our wives and say, well, it looks like we're coming home, honey, was when the head of the OPP commissioner or superintendent testified, who's the head of their intelligence unit. And he's the one who is initiated or heavily involved in what we now know is called Operation Hendon. They had the code word for us. And he's confirmed that they found no evidence of attempted insurrection. They found no evidence of terroristic activity. They found no evidence of foreign influence. They found no evidence of ideologically motivated extremists. They have found no evidence of serious threats of political or other violence, etc. All of these different permutations of things that the government could cobble together. So and then of course we ask every official after that, do you agree that this inspector is the one that would have the most intelligence and information and evidence regarding these things, right? Yeah. Do you agree with his testimony? Yeah. Or they'll say, I don't know. And we say, right, you don't know, do you? Right. So, and what's also been fascinating is the only legal teams that have been actually asking questions and drilling down on the evidence as to what this inquiry is about, was the invocation justified? Was Prime Minister Trudeau and his cabinet actually facing an existential threat for our country. Remember, this is the successor to the War Measures Act. So in previous instances, it was invoked in World War I and World War II and the FLQ crisis. Did this really come to meet the standard? Whereas what the other legal teams are doing is like, the legal team for the Ottawa Police is like, oh, well, it was the RCMP's fault. And then the legal counsel for the OPP is like, oh, it was the Ottawa City Police's fault. And then the legal counsel for former Chief Slowly, who resigned in the middle of all this, is it wasn't his fault. It was the police board's fault. And so we've all watched in horror the dysfunction, the egos, the blame game going on behind the scenes, and it's all being aired publicly. You get the sense the commissioner, Justice Rouleau, is just sitting there going like, really? This is what I'm having to deal with here?
Infighting of a high school nature. Justice Rouleau, he asked a question which really, put me in the thinking that he's got this understood properly. When he asked a question of one of the police officers after had been cross-examined, and said, look, when you were getting everyone out of the footprint, and Keith, I've got to say, the fact that they refer to the protesters as a footprint, as though they're pollution, it's a carbon footprint, it's a footprint like they're pollutants on Ottawa. I think that the wording is interesting. But he was asking the police officer, he said, after you start pushing everyone out, did you give them an option as to where they could go to peacefully protest? Did you give them an option where they could go legally to continue this, but just not in Wellington or on Wellington? And he said no. Do you think the judge is getting how absurd this is, or do you not have any indication one way or the other?
I can only speculate, and I know that's what you're asking me to do. He has asked that question at least six or seven witnesses now. And I think what he's realizing is the government and the police were overplaying their hand, enforcing, not taking opportunities to de-escalate and create dialogue and find a Canadian way out of this protest and this situation by just, you're all going to wave the right flag and, hang your heads in shame and leave here humiliated now, or we're going to beat you up. And, there was some testimony yesterday about how they cleared the streets of vehicles. And I've had several firsthand reports of people reporting this to me. It wasn't a truck, a transport truck that they were necessarily smashing the windows out of. They did that. But if you happen to have your SUV or your rental car or your pickup truck that was clean and had no flags and no markings on it and had an Ontario license plate or a Quebec license plate on it, and you happen to be parked downtown, they came up and smashed out all your windows. Like, why even all of them? Why not just why not just one?
Open the unlock the door.
Yeah, there's a power lock. You don't even have to go around inside and like old school, and pull the button up. And then they would turn the key on to accessory mode, and then they hauled it out to the storage yard, and they left it like that. So all these vehicles are full of snow, with all the electronics in a modern vehicle. Like, why did they have to do that? There were so many things. Oh, the real one that's been interesting that we're getting out, and we're going to have witness testify to it, is this practice they had of, after they process someone, they do a snatch and grab, pull them through the line, take them to an arrest lineup. They're zip tied behind their back. Their gloves have come off. I met one person who actually started bleeding because of the zip tie on his wrist. No glove. He was showing me he still doesn't have feeling in 3 of his fingers because of the frostbite. And then finally they would get their primary processing, and they'd say, all right, we're not going to charge you. We're going to release you. But they didn't release them They sent them over to another lineup where they stood up outside in -25 with not including the wind chill. Then they put them in a paddy wagon. Then the paddy wagon sat there for 2 or 3 hours. And then remember, they've been told they're not under arrest and they're going to be released. So at that moment, the moment they didn't let them go, it's called kidnapping. All right? That's illegal detainment. So the paddy wagon would then drive them to remote locations outside of the downtown, rural areas. They'd release all these people. Could you imagine their bewilderment? You know, they're dehydrated. They haven't been able to use a bathroom. They're frostbite. Many of them beat up. They cut the zip ties off and they drive away. And here they are. There was no building for shelter. There was all of their phones were dead. If they still had their phone, because a lot of them lost it in the melee, they were all dead from being in their pocket in that amount of time in the cold. And there was no payphone or business or anything else. And to do that to hundreds of Canadians, like, does that sound like Canada to you? You know, so
I can't say what it sounds like to me because I'll get in trouble. It's egregious. And people don't know about I knew the details about this from some people. I mean, when we were down there, people would come back, like, they hauled us off. I was outside, you know, beaten up, handcuffed, and hauled off. But I actually didn't know about the extent of the injuries. I didn't know the extent of, you know, the inhumanity. Let's leave it at that.
yeah. And some of these people they did this to were war veterans that went to Afghanistan to help fight the people of Afghanistan get human rights.
People in the chat want me to say it. I'm not saying it. I think it's criminal. I think it's criminal. And I don't know how many of them are suing for damages. I don't know how many of them can press charges against the authorities. I don't know how it works.
Well, I don't know if you saw the testimony, because we put that to the witnesses, the police witnesses, yesterday and the day before. And so their answer was, because we want to know who came up with this idea. Like, there's no way all of these different police officers that were doing this on their own, right? This is not one instance of one paddy wagon getting lost and kicking out 30 Canadians. It was happening on scale and at a process level. So someone, and it's not in any of their operational plans, because we've reviewed all those and it's not in there. So whose idea was this and who gave the order for it to be? And each of the senior officials with the Ottawa Police that we've asked about have completely dodged the question. And so we don't know who actually gave that order. But it's just one of the examples of things that have come out each day. We've had a significant instance. Well, even the inspector with the OPP, if you get a chance to watch this clip, when Brendan Miller closes his cross, and watch the facial expression of this Inspector Baudouin with the OPP, who is the head for the liaison teams, the whole liaison program of police liaisons. And it, you know, the documents that we're putting up on the screen show that this inspector had come up with a plan, a de-escalation and negotiation plan that was turned out to be parallel to what myself and others did in our deal with the city to de-escalate. But it was going to be at the federal level, and they were going to mimic it. And it got approved by Lucky, the commissioner of the RCMP, and everyone else. And unbeknownst to this inspector, his de-escalation and negotiation plan for the federal government to interface with the Freedom Convoy in Ottawa was actually presented to the emergency security meeting of the cabinet on the Sunday night. And so our lead counsel, Barrister Brendan Miller, puts it to him. He said, you know, he got him to be proud of his plan. And then he informed him, did you know, sir, that your plan was presented to the Prime Minister and cabinet at 7:30 on this day? And he was like, wow, really? And you also know that they rejected it and they instead decided to invoke the Emergencies Act. And Brendan folds up his computer and walks away, because it doesn't matter what the guy's answer is right there, right? And you look at his face, this OPP inspector in his dress uniform, and he's just like, that was the first he knew that his
it was,
plan made it all the way to the prime minister and his cabinet. And rather than build on the success that we'd already achieved that day, or we were achieving with the implementation of the mayor's deal, they said, no, send in the goons.
it's amazing because it came out today as well, where there's correspondence and it says, the GOC, Government of Canada, is losing faith in the OPP or OPS, whatever. It was like Trudeau and his regime had one plan and one plan only. It was bend the knee, apologize, go home, or else we're doing this. And I talk about corruption and how it's insidious, it's subtle. It's not Trudeau saying do it or else. It's the Government of Canada is losing faith in the OPP because this protest is still going on. It's embarrassing us, and it hasn't been put to an end yet. And if you don't do it, we're going to do it. And we did it despite the fact that there were venues, active venues of legitimate, meaningful de-escalation. The only problem is, Keith, it's so bloody long. I mean, the days are long, 9:30 to 6:30, and the judge is
6:30. That's an early day. There's one Friday night we went till 9.
That's
it's not uncommon for us to go to 7 or 8. And although lately it hasn't been too bad, and we're all under notice that at some point, if we don't stay on, if we start to lose traction on the schedule, we're going to be sitting on Saturdays. And each day we have to review all the new documents that have been filed, get our head around those. We have to identify the documents by 5 o'clock that we want to cross on the witness who's coming up 3 days from now. In addition to that, we continue to interview our clients. We continue to expand our witness list. We're in constant negotiations on an ongoing and daily basis with various witnesses that we would like to have added. And we're doing that every day. And then once we know we have a witness that's being added, doing witness prep. So it's absolutely like everything I've been doing since I signed up for this mission. It's full on. Is
there anything enjoyable about it? I mean, the idea of being away from your family for 2 months, is the fulfillment of what you're doing enough to get you through this?
There's 2 things I'd say on that. One is I have met the most amazing Canadians, Tamara, Tom, Chris, and on it goes. Danny, I could keep going. And the legal team that I'm working with is wonderful. So that's a reward. And the other is we got to do this. There's not an option here. This is not an option. Too many bad things. And they'll tell me about what happened. They'll tell me about their 7-year-old daughter, or they'll tell me about how they had to say goodbye through a window to their mother who died, and not be at their side. And there's a lot of hurt out there. And these governments have engaged in egregious activity. And this is not sustainable. That's not a society or a country that believes in that kind of overreach and nanny state and government. Oh, we'll keep you safe. No, I want a little bit of risk in my life. Thank you very much. And I'll worry about being safe. I don't need you to do that. You're pretty damn incompetent about everything you do. I hardly think you can keep me safe, even if I wanted you to. So what we're doing is very important. And I appreciate that. I sleep well because I know the importance of the work. And I really think we're on the right side of history.
Okay, fantastic. Now I know the judge is very punctual, and it's 1:53, so you probably have to go back. Just before I forget, the visually impaired witness who was testifying for Ottawa, who alluded to the fact that she might have gotten COVID from the protesters on the street when they came up to her. That's and I mean, this is the evidence that's supposed to support the invocation. Preposterous.
Keith, one more.
Yeah,
the police chief Bell talked about violence. So Brendan pushed him on it. Brendan Miller, who's just, if the only thing you get a chance to watch is watch Brendan's crosses, they're just spectacular. And he pushed him on it and got Bell to admit that he wasn't talking about actual violence. It was felt violence.
Perceived
In other
violence.
words, a perception. So now we know we've got potential decline in service levels of Uber Eats. We've got microaggressions, and we've got felt violence. And we're really expecting someone to soon to be testifying about how they experienced the felt violence different than someone else.
It was that clip was going around. I mean, yeah, I'm watching and I'm like, what violence? What violence? And then Brendan comes in. He's like, yeah, it was here is a list of people who were arrested. They were not arrested for this, not arrested for that. Where was the violence? It was the perceived violence from the community. They didn't feel safe. Outrageous. Your team is doing amazing stuff. And I suspect it's going to be fun to watch you testify. I will live stream that on the main channel. That'll be very interesting.
I asked Brendan if he wanted to prep me for cross, and he said, no, it's okay.
There are some witnesses who are useless to prep for one of two reasons. You could train them for 3 weeks. It won't change anything. And they're going to be so good. They don't need training. Keith, we know which one you're going to be on that. You changed the QC to the KC, King's Counsel now. Keith, thank you very much. As always, I mean, if you can bounce in whenever you can, because sure. I'm running the stream live on my other channel and on a separate live stream, so people can watch the hearings, rewind, comment with each other. But anytime you want to come back on, please let us know what the latest is, and we'll do it.
Thank you, and please, if you can spare a little bit, don't forget to donate to the Justice Center for Constitutional Freedoms as you can. We need the juice to keep going. I'm
going to make sure everybody knows that. I'm going to do it myself after this stream. I'm going to put the link there, blast it around. You'll notice an uptick if our audience is very active. They'll do something. Keith, thank you, and we'll talk soon.
Yes, absolutely. Thanks for your attention on this and your helping people understand what's really going on around them. So I appreciate it.
My pleasure. My pleasure. I'll talk to you soon.
Right. Thank you very much.